Hello, I'm John Cook, Deputy Director of the Federal Judicial Center. A few years ago, the FJC entered into a collaboration with the American College of Trial Lawyers to create a program demonstrating how judges might deal with challenges in the courtroom. That program, Judicial Demeanor and Courtroom Control Practices, was so well received that the ACTL and the FJC decided to do it again, this time focusing on what comes before trial. Judges learned quickly how important it is to establish early and continuing control over each case. Effective case management can discourage waste, clarify and facilitate each step in the pretrial process, and streamline and improve the quality of the trial, not to mention making the judge's own life more manageable. Sometimes control can be established and maintained easily, but often there are challenging situations, no two exactly the same. There may be a disparity between the parties that makes it hard to be, or to appear to be, neutral, or an issue that's so technical that it's not obvious to the uninitiated what the question is, let alone the answer. Sometimes just the personalities involved make things difficult and unpleasant. With the help of the ACTL, we've produced video vignettes illustrating 7 of the most common and difficult challenges judges face in case management. We're going to look at each scene and then come back to our panel here in the studio to talk about what the judge did that worked well and what he or she might have done differently. To present a range of perspectives on these issues, we've assembled a panel of experts from both sides of the bench. Judge Barbara Rothstein recently wrapped up a term as director of the Federal Judicial Center, and before that was a district judge in the Western District of Washington for more than 20 years. Judge Jack Zuhari is a district judge for the Northern District of Ohio. And to provide us with the practitioner's point of view, we're fortunate to have with us 4 of the nation's top trial lawyers. To discuss the civil scenes with the judges, we have Greg Joseph, the senior partner of Greg Joseph Law Offices in New York City and the president of the American College of Trial Lawyers, and Mike Smith, a senior trial lawyer with Christian and Barton in Richmond, Virginia, who serves on the ACTL's Board of Regents. A little later in the program, we'll see some scenes from a criminal case, and for those discussions, we'll be joined by 2 criminal litigation specialists, Thomas Bondurant of Gentry, Locke, Rakes, and Moore in Roanoke, Virginia, and John Siffert at Lankler, Siffert, and Wohl in New York. Thank you all for being here. We're going to start with a deceptively simple problem that can be extremely challenging for the judge: how to deal with a pro se party in a way that treats both sides fairly. Let's watch.
All right, this is the first conference of Pelican versus Destiny Records Incorporated.
Your Honor, if Your Honor please, I notice that there is no court reporter present. I would prefer, and I think Your Honor would as well, that this conference be on the record.
Sir, I don't need a court reporter at this time.
Very well, Your Honor.
And you are, I'm guessing, Mr. Pelican?
It's actually not Mr. Pelican, it's just Pelican. That's my legal name. I just want to say I am so happy to be here. I mean, it just gives me a little faith in life that a guy like me can walk into a building like this and get justice against a Goliath like Destiny Records.
Well, thank you, sir. Pelican. And you are?
Jonathan Dinmont for the defendant, Your Honor.
Okay, well, welcome to both of you. And I trust you've both read my practice guide.
Oh,
yes, Your Honor.
I did. I read that. Wow, you really thought of everything.
Well, I hope so. Shall we begin with a case summary, Mr. Pelican?
Judge, I really did read your book, but I'm not really sure I know how to do a case summary.
It's nothing complicated. Just tell me what your case is about.
Oh, yeah, I can do that. So, I was in a band with these guys for a number of years, Dafe, Jonzo, and Flambe. And you might have heard of us, Pheromone?
Yes, I'm familiar with Pheromone.
Well, I used to be their drummer. You know, sang a little backup vocals, but the main thing that I did was write the songs. That's my gift. Take a thought or a memory and turn it into a song. You know, we played some clubs and bars, no big successes, but we're doing okay, doing all right. And then this one song came out, we played on the radio quite a bit. You might have heard of it. Stand up, sit down. No? Stand up, sit down. Well, anyway, we got picked up from Destiny Records because they heard that song. It's kind of catchy, you know. I can't tell that this power ain't on my own. Oh.
It is catchy.
Well, anyway, the band decided that they didn't want me anymore. So somehow they get this record deal with Destiny Records, and I'm screwed. Excuse me, Your Honor, but I was out. So after the band broke up, I ran into some hard times, lost my day job, and actually ended up in a shelter for a little while. Had to go to the hospital. Then I heard this other song I wrote. You might have heard of it, Fall into Space. Fall into space, catch me if you can.
Yeah, you wrote that?
I did. Anyway, I'll be honest, I was kind of floating through life at that point in time and wasn't sure if I was actually hearing the song or if I just kind of made it up in my head, because, you know, I do hear music in my head all the time. That's kind of how I...
Okay, what happened next?
Well, anyway, I heard the song again, and this time I was with somebody, and she heard it too. And she had actually heard me sing that song before it was out on the radio, so, you know, she found out that the band was making all this money and claiming that they wrote the song. So she hooked me up with her lawyer friend.
And where's that lawyer now?
Well, we didn't really see eye to eye on a few things, so we decided to part ways. But anyway, I guess that's it. Oh, and one other thing, Judge. You know, I'd really kind of like to sue Dafe Jonzo and Flambe, too, if it's not too late. Because, you know, I really think they're the ones that should get sued. I mean, Destiny, I'm not even sure if they did anything wrong. I mean, they might have just believed those guys when they said they wrote the song.
Let's hold that thought for later, sir. If you're finished with your case summary, I think you should stop there, and I can hear what Mr. Denman has to say.
Your Honor, this entire lawsuit is frivolous and entirely without foundation. He practically admitted it just now. We have no reason to believe that plaintiff wrote the song in question, and he seems to be unsure about quite a few things, as I might add, 4 years ago he was when his substance abuse prevented him from signing with Destiny Records along with the rest of his band.
Mr. Denman, let's keep this courteous.
Well, certainly, Your Honor. However, even if this man did write Fall into Space, the fact of the matter is that Destiny would have no way of knowing that. We've got third-party claims in process right now against Pheromone because they represented to us that Mr. Dufresne had written that song.
Yeah. It's those ex-friends. They're the ones that should be sued. Wish I could see their faces when they get a summon from me. They probably think I'm dead. You know, I feel like with Destiny, it's just like, whoops, sued the wrong guy. Maybe I should just tear up this paper and sue the right guys.
Mr. Pelican, just wait. Before you sing another note, I strongly, strongly urge you to call your lawyer or get a new one. I'm going to continue this matter for 30 days to give you a chance to do just that.
Pardon me, Judge, but this man's chosen to come here without a lawyer, and it sounds to me as if he's belatedly got a pretty good handle on who he should really be suing. Now, I'm willing to consent to a dismissal because it sounds to me like we've got an agreement.
Well, the judge obviously found herself in a rather difficult but not all that unusual situation here. Let me ask our two judges first how she did and what she might have done differently.
Not having a court reporter is bound to get her in trouble in the future. Dealing with pro ses is definitely one of the recurring problems that judges face. Mr. Pelican, or Pelican as he prefers to be called, is a prime example of it. I would predict that in the future you will get many different versions of what took place at that pretrial conference. And the judge runs the risk of being caught in a, he said this, no, he said that, which all could be resolved very easily if there was a court reporter.
Judge?
I agree with the court reporter comments by Judge Rothstein. Pro se cases are difficult for judges. They require flexibility. They require often more time spent. And in this first conference, I would have asked some questions to help guide the plaintiff in the storytelling. I might have tried to minimize some of the singing. And it's not fair to expect the pro se plaintiff to understand the court rules and what's expected of them. And so I think the judge needs to be a little more involved in that first conference with the pro se plaintiff. I also would have discussed a little bit more about the attempt to secure a lawyer and had a conversation about how important it is to have a lawyer, if he could get one, because of the difficulties in maneuvering in the legal system. And many courts now have a program to allow a judge to assist a pro se plaintiff in obtaining free legal counsel. There's a list of lawyers who sign up for that, and I would certainly have looked at that as an option for this plaintiff. And finally, I would have encouraged a strict deadline, whether it's 30 days or 60 days, to allow this plaintiff to either secure a lawyer, whether it's the old lawyer or a new lawyer, also to perhaps come to a conclusion about whether he wished to amend his complaint or refile a new complaint. In other words, a little prodding of the process.
Let me ask Mr. Joseph and Mr. Smith, you've probably sat across the table from people like Pelican from time to time. From your perspective, what can the judge do or should the judge do when dealing with somebody like that?
John, effective in October of this year, 2011, the college has adopted a code of conduct for lawyers and judges in dealing with self-represented litigants because it is a problem. And there are just a number of suggestions that judges can consider and the lawyers have to take to heart. Things like advising the self-represented party about ex parte communications with the court, explaining the significance of deadlines, telling lawyers to avoid unnecessarily technical arguments when you're dealing with someone like that, and to avoid communications unless they're absolutely necessary off the record with that kind of person. There are a number of other suggestions that the judge might do, permit or prescribe simplified kinds of pleadings, discourage technical pleading kinds of motions, and generally to require the lawyer to see the extent to which there can be stipulations, written stipulations, to try and cut through to the truth. It's a difficult situation for everybody involved.
John, I really don't have much to add to this. The points have been hit. I do appreciate the fact, though, that for a judge and for a lawyer representing a litigant on the other side as well, this pro se problem is laden with landmines, and the judge in particular is going to strive to make sure that litigants have their day in court. But at the same time, the court is going to strive to keep control of the situation, and that presents unique problems with pro se litigants.
If the case comes back in 30 days with still no lawyer, what would you do?
Well, I would again repeat and caution and explain some of the pitfalls that this individual is going to encounter if this case continues. For instance, point out that there are such things as the rules of evidence and that there's courtroom rules and regulations and point out that this person really may not be familiar with, trying yet again to convince the person that this is dangerous area he's getting into without any legal training at all. The judge is caught between a rock and a hard place. You want to give extra attention and have more patience with a person who is unskilled in the legal arena. On the other hand, it's terribly unfair to the defendant for the judge to bend over backwards to help one party. And striking that balance is extremely difficult. I would mention one word that it requires, and that is patience. Dealing with a pro se litigant is a taxing situation. This judge did display a certain amount of patience that was admirable in this situation.
Okay, thanks. Let's move on to our next scenario.
Good afternoon, counsel. Ms. Price, I understand that you're here for the plaintiff.
I am, Your Honor.
Mr. Driscoll, you represent the defendant.
I do, Your Honor.
I think both of you have had an opportunity to meet Mr. Coons this afternoon before we began the conference.
Good afternoon.
All right?
How are you, sir?
So let's get down to work. I think both of you are familiar with my expectations for a Rule 16 conference. I expect the counsel for the parties to have met and conferred in advance of the conference. I expect counsel to have agreed on a proposed trial date and on proposed deadlines for discovery, dispositive motions, and for joinder of third parties. If you met and conferred, it must not have been very productive because it appears you have agreed on almost nothing. Now, which of you wants to tell me why that is?
Well, Your Honor, I'll be glad to do that. We're very much aware of your preference for moving your cases along, and I would like this case to be tried in February. I have a very unusual circumstance in this case, and I've tried to make that point fairly to Ms. Price. The CEO of my client is to undergo heart surgery in January. He is going to need time in which to recover and to prepare for this case. And I think this case should be set in May or June. But naturally, I was not able to get counsel to consider those circumstances, and that's where we stand on the scheduling. I think May and June is very reasonable.
Ms. Price, that seems a reasonable enough position to me. How do you respond?
Not that this comes as a surprise to me, Your Honor, but once again, Mr. Driscoll has been selective in what he has told the court. As he is well aware, I have a trial that is scheduled to go the entire month of May, and I have a commitment in June.
The whole month of June?
Ms. Price, what's the nature of the conflict for June? I understand the May trial, but what is it for June?
I don't mind the court posing the question. I do mind Mr. Driscoll's reaction since he knows full well what the commitment is. Your Honor, June 11th is my 25th wedding anniversary. As I think you may have heard, my husband Bubba retired recently, and after he's put up with me for 25 years for our silver wedding anniversary, I gave him a 3-week cruise, taking up most of the month of June as his anniversary present.
Well, I hope that both of you will understand the court's position on this. I really hate to push this case until July. It's an old case, it's been a fractious case, and we need to get it resolved. Might there be somebody else in your law firm that could handle the trial so that we can keep things moving?
Well, honestly, Your Honor, I wish there were, but mine is a very small firm, not like Mr. Driscoll's, which is the biggest in the city. I have just 2 associates, and they're very talented young people, but neither one of them is ready to be handling a complex trial like this, Your Honor.
Your Honor, we'll do anything to cooperate. Ms. Price has a partner, but he probably will be back in rehabilitation by June.
Mr. Driscoll, that's none of our business. Now let's move along here. But I will ask Ms. Price if she thinks her partner would be able to relieve her and try this case.
I'm sorry, Your Honor, but my partner would not be available. As Mr. Driscoll knew, and I suppose intended to have put on the record, my partner has a serious addiction problem and
Your Honor,
is
it's
undergoing
a very sad
treatment.
situation. We understand that. Ms. Price's partner has had...
Wait, excuse me. Just a minute, please. I'm sorry, I don't mean to talk over counsel. Your Honor, I would propose that we go to trial in December.
Now we may be getting somewhere. That would mean an expedited discovery schedule.
Absolutely.
Well, Your Honor, that will not work.
Why not?
We cannot afford an expedited discovery schedule set for December when I have the CEO of my client is scheduled the following month for heart surgery. He's hardly in a position where he can help with discovery, which I'm sure is going to come in box loads from the plaintiff's firm.
Well, with all due respect, I seriously doubt that Mr. Dixon is going to be putting pencil to paper or fingertips to computer keyboard to write the interrogatory responses. He doesn't even pick up his own toothbrush.
Now, Ms. Price. Now, Mr. Driscoll, it seems to me that Ms. Price has a point. While CEOs can and do play a major role at trial, I think it's unusual for them to be heavily involved in responding to the day-to-day discovery in the case.
Your Honor, he needs to be, as the CEO, a participant in the discovery. But I need to raise with you, even if I could overcome the fact that a man who needs heart surgery is going to be in the middle of discovery, we need to face the fact that that firm, the plaintiff's firm, is not going to be ready in December. I've had experience with them. Their track record's very clear, and that's what's going to happen.
Well, excuse me, what is that supposed to mean? Our track record?
Mr. Driscoll, I have to say, I think this is just entirely inappropriate.
Your Honor, it's not my intention to be inappropriate, but you need to know, I've just finished a case with this firm, and they cannot meet a deadline. That will not work with a December trial schedule, with the problems that we already have, and with the track record they have of noncompliance.
This is ridiculous. You have no right to put anything in front of the judge that relates to another case. And once, in one case, we missed one deadline, which is hardly unusual, Mr. Driscoll.
It's hardly unusual for you, counsel.
Counsel, both of you. I really don't need to hear about a case that's not before me. I'm having enough trouble with the one that is. Now, no more personal bickering, and let's move on about scheduling, please.
Your Honor, I understand the court's admonition, but the bottom line is that this court should not be inconvenienced because counsel can't provide a backup while she takes a 3-week vacation.
Well, excuse me, I can understand how you would have no comprehension of the importance of a silver wedding anniversary, given that you've tried 3 times and never made it 3 years.
Counsel.
And I am
Counsel.
sympathetic to Bubba.
Hold on, counsel. This is tilted even further out of control, and if we can't discuss these issues with civility, then we're just going to have to call an end to the conference.
Well, Your Honor, I feel that you're accusing me of being uncivil when it's this man who came into this courtroom, put my partner's psychiatric condition on the record, and raised the issue of a 3-month delay, and then seeks to blame it on me.
Her attitude, the volume of her voice speaks
Mr. Driscoll, Ms. Price, stop it. Both of you, stop. I've heard enough for the afternoon. Your behavior has been unacceptable. I keep ready at hand for conferences like this, which happily don't happen very often, copies of the American College of Trial Lawyers Code of Pretrial and Trial Conduct. It's an aspirational code. It seeks to assist lawyers in treating each other and the court with respect and civility. I'm going to adjourn this conference for now. I want each of you to read and, if necessary, memorize what's in that code before we reconvene. You can screw up your own lives by this personal bickering and use up your own time and spend your own client's money if that's what you want outside of these chambers. But in my court, civility reigns. Do you understand me, both of you?
Yes, Your Honor.
Yes, Your Honor.
The hearing is adjourned.
Well, hopefully you all don't have too much experience with that kind of a situation, but it does occur, obviously. Let me ask the judges, what could the judge here have done to get control a little sooner?
It didn't take more than a minute or two to see what the situation was between these 2 attorneys. And when you have that much bitterness built up between the attorneys before they even get to the Rule 16 conference, the judge has to step in really soon and make sure that the prevailing sentiment at the conference is civility. She let it go much too far. I mean, there were things that came out there that never should have come out, and you know, it only exacerbates a situation, I believe, between counsel if you let them behave like that on the record, and they see that the court's not going to take control. And of course, the final thing, at some point, I'd be curious to hear others' comments, but at some point, if the parties can't agree, the judge has to just step in and set a date. You can't let them, and they're not going to come back any closer to an agreement, not these two, when they come back whenever she has the next conference. Don't you agree, Jack?
I do agree. She made a great speech, but it came too late. The speech she made at the end I would have made much sooner. And I believe at the first instance where the lawyers began bickering at each other, I would have directed them to make their comments to me about the issue at hand and not to make comments to or at each other about these extraneous issues. I would have set a trial month at the very least and let them know that's going to be our target, absent some good cause, and try and get them back on track. I would also add that the reference to the American College Code was a good one. I require it for pro hoc vice admission into my court. I have a copy or two or three in the chambers, and there are some cases where when lawyers begin to go astray like this, I pull the copy and say, I think you need a refresher.
I was a bit surprised that the judge let these lawyers go at each other like this. There's not going to be any more agreement next time than there was this time. And I'm quite surprised, actually, that the judge didn't send the clerk out to get the court's docket, and the court set the dates right there with them sitting there. I was kind of surprised that didn't happen.
I think you have to bear in mind that the judge effectively rewarded the defendant and therefore encouraged this behavior, because now all you're doing is letting time lapse. If December was a close date before, it's gone now. And she doesn't want it to go into July, so she's now rewarded the defendant who started the behavior, and that's why just setting a date, taking control, is really important.
When you're facing a cantankerous opponent like that, what can you do to help the judge, and what can the judge do to help you?
Well, first, don't engage, either before the court or otherwise. Speak only to the court, never address the other lawyer, and if necessary, ask that the judge direct that all comments be directed to the court. But most judges will do that. Avoiding direct engagement is critical to maintaining any kind of a civil atmosphere when you're dealing with someone like that.
Greg's right about that. That not responding slows down the gotcha game, for sure.
Mm-hmm. And I think you can set a judge can set a tone at the very beginning, the minute this behavior begins. You can set a tone and say to counsel, look, life's too short. You're going to be working together on this case for months to come, and if you continue like this, you're going to be back before me fighting about every little thing. You need to try a different tack. You need to try to get along. They were worse off at the end of the conference than they were in the beginning. I mean, they may have disliked each other in the beginning, but by the end of the conference, after the referrals to the rehabilitation of the partner and the marriages of the defense counsel, these guys really are building up to hating each other.
And the judge, it was obvious, the judge knew at the very outset that she had a problem here, that there was some difficulties.
Well, she knew because they hadn't agreed on
Right.
anything in response to her order. But sending them back to do it is an exercise in futility.
One thing that occasionally is done is just sending them out into the jury room right now to do it and requiring that they come back with some dates. I don't know if that would work in this circumstance.
They might kill each other.
That would actually help solve the problem.
I'll answer the question, how could the lawyers have helped the judge, with the following advice, and that is, I know it's very difficult not to fight fire with fire or not to engage, but when the other side begins to do that, you need to take the opposite course and redirect the conversation to what's appropriate. You can help the judge in that way, and then the judge can pick up on those efforts as well.
Good. Any other thoughts? No? All right, well, let's move on to another scenario.
Counsel, the purpose of this conference is to resolve the issues raised by your competing proposed discovery plans. Then we can get an order in place.
Okay. I think Your Honor can see from our proposed discovery plan that Mr. Deaver and I are in a fairly good agreement on most of the issues, except something quite serious, I'm afraid. Even though we only filed this complaint 1 month ago, Mr. Deaver and I have been negotiating issues related to this claim for over 9 months. And, Your Honor, there is still no effective litigation hold in place. We need exhaustive discovery on why that's the case and if there has been any spoliation of evidence. This is why Mr. Deaver says 10 depositions and I say 20, because I believe that we have to vigorously and exhaustively examine this issue of spoliation of evidence.
Well, Your Honor, I think it's more complicated than that. Attorney Parham wrote me 9 months ago, that's true, and indicated that the clients had some issues between them. I think she described them as kinks. In fact, her letter at that time, which I was just looking at, indicates we want to continue our mutually advantageous business relationship. Nothing to indicate that they had a complaint in their back pocket that they were ready to file. In fact, when they did bring the action and gave proper notice, we put a litigation hold in place. There is one in place. And as far as I know, nothing has been destroyed, nothing's been lost. This is really just a fishing expedition to put burden and cost on my client.
Wait a minute, Your Honor. This is, first of all, that letter, he read the last line of the letter. The whole letter is about our dispute. Mr. Deaver tells this court has the temerity to come in here and say they put a litigation hold in place. It's a spam email. It says don't delete anything on it. It goes to low-level employees. This is a high-level board executive case. There is no notification to any board members, no notification to any senior executives. No IT employee has been put on notice to preserve any electronically stored information. They didn't even ask for a return receipt from the people who they sent the emails to. There's been no retain order through the IT department. There's been no forensic images taken of computers of executives. The whole hold is a joke. It's not effective.
That brings us to an interesting question. Ms. Parham, I can see how you would view the defendant's hold as inadequate, but if you wanted a voice in crafting a hold that was more to your satisfaction, why didn't you ask for a preservation order when you filed the lawsuit?
Well, Your Honor, I'm not used to being required to represent both sides in any action. Mr. Deaver has the obligation to create the hold, and I assumed, as I do in all of my other cases, that Mr. Deaver would responsibly create a litigation hold that would reasonably lead to the preservation of potential evidence in this matter. I don't go out and do his job for him. I think that's his work.
Well, Your Honor, I'm perfectly happy to do our job, and as I've explained to you, we did our job in this case. We have put a litigation hold in place.
Counsel, we have too much to cover to argue about this. I don't know enough today to enter relief on such a fact-intensive issue, and you aren't going to convince me that I do, no matter how scintillating the oral advocacy. If there's a proper basis for a motion, file it in due course. Get me the facts so I can make an informed decision. I need to understand why it was reasonable for Pasco to assume that Devenco would place a hold that meets Pasco's standards. I also need to know more about when Devenco should reasonably have anticipated litigation so that a duty to preserve attached, and what steps Devenco took once the trigger date occurred. And I need to know more about what data was lost and what prejudice that might cause. But remember, less is more. Don't take 20 pages to tell me what you could have said in 10. I don't want litigation over discovery to take precedence over litigation on the merits. Don't get me wrong, Pasco has the right to explore whether there has been actionable spoliation, so Pasco can add a topic to its 30B6 notice. It can ask questions at the 10 depositions. If those initial forays make a case that further discovery is warranted, fine. But until the sideshow is ready for the big tent, let's move forward.
There is something forward-looking that is critically important that we address at this point, and that is the issue of the restoration and preservation of the backup tapes. I understand, Your Honor, that your standing order does not usually allow restoration because of the cost involved, but this case is different. What Devenco has is one of the most aggressive backup and deletion programs I've ever seen in my practice of law. They keep emails for just 30 days before they put them on the backup tapes. And then they have a 12-month recycling program. So when you think about the context of this case, Your Honor, in that we have been in a dispute for over 9 months, that if there's a 12-month rewrite over the backup tapes, there could have been something that was 3 months prior to when we first started taking notice of the claim that is being overwritten today as we sit in your chambers. I would ask the court to enter an order that no backup tapes be overwritten going forward.
Your Honor, there is nothing unusual from a commercial practice's point of view about this situation. The electronic data backup tapes are part of a standard disaster recovery system. The estimate of what would be involved to restore it, as counsel presents this to you, is $500,000. $500,000 just to restore the backup tapes. Moreover, after we restore them, they've got to be searched and reviewed, a staggering additional amount of cost that we can't even estimate at this point. And then you have no assurance that you're going to find the documents that you were looking for that would satisfy her curiosity. The Sedona principles make it clear that when you're going to take the drastic effort of restoring backup tapes, which is essentially for a catastrophe or a natural disaster, the party seeking that has to show that the cost and the impact in terms of burden are well outweighed by the relevance and the need. In this case, they haven't made that proof. This is a disruption of our client's business that really is intolerable.
Well, preservation is an issue separate from production. If you haven't already, you need to make sure that whatever backup tapes exist aren't destroyed or overwritten. When we know more, we can address the proportionality question and address whether it makes sense to restore and review them. How much is at stake in this litigation?
Our damages claim, Your Honor, is well in excess of $500 million.
We think that's grossly exaggerated and not meritorious, but our counterclaim is $50 million.
Right, and I want Santa to bring me a pony. What's the reasonable expectation of what's at stake?
Your Honor, we would not have put it in the complaint unless we reasonably expected that our damages claim is in excess of $500 million, and we'll have experts to testify about that.
We believe our counterclaim is very solid at $50 million.
Okay, so you both agree that tens, if not hundreds of millions of dollars are at stake. That justifies substantial discovery costs, and both sides appear able to foot those costs. But I can't intelligently address those issues yet, so I want the parties to get together and give me the information I need. How many tapes would need to be restored to meet Pasco's requests? And at what cost? What would be the cost of restoring and searching a sample tape? And what is that likely to tell us? Once these questions are answered, I can assess whether to order restoring and whether the cost of that process ought to be shifted. What else?
Well, obviously the judge was dealing with a difficult problem here that existed before anybody even walked into the room that day. What, if anything, could the lawyers have done, or could the judge have gotten the lawyers to do that might have helped the situation at the outset?
Yeah, the judge actually did a fine job. He identified the issues. The principal problem started long before the lawsuit, and that was that the lawyers now making demands for preservation never sent an unequivocal letter that clearly demanded the preservation. And then the parties didn't get together when they knew they had this issue to either address it and try to come up with a date in which they'd agree that preservation was required, or at least alert the court as to what their positions were, and instead they took extreme positions on both sides that were of no use, no help to anybody. The judge was right that first you should do some discovery before you start ordering massive restoration, because that's extraordinarily expensive and very disruptive to any kind of a business operation, but he was also right in preserving what there was. Rulemakers are now considering a preservation rule that would help, at least in the notes, if not in the rule, give some benchmarks of preservation that would be useful. But until then, I think this judge did a fine job.
What I thought he did a good job at was maintaining the status quo, acknowledging that he couldn't deal with these two issues that day. With respect to the retention and the spoliation issue, he told the lawyer that she could take a 30B6 deposition, that if she needed additional deposition, she could, that if she was so advised, she could file a motion. And in addition, in dealing with that issue, this judge laid out and filleted for these lawyers the questions he would like asked if the motion were to be filed. With respect to the restoration issue, he told the defense lawyer, don't write over any more tapes, status quo. He told both of them to get together, inform me. How many backup tapes do you need restored, and how much is it going to cost? He decided, he mentioned that he would decide the proportionality question after that was done. By the way, in a very subtle way, I thought he did a great job in getting a good piece of the proportionality question behind it when he started talking to the two lawyers about what they really thought the addendum or the damages were with respect to the claims and the counterclaims in this case. This is an exploding issue, this e-discovery. The opinions are coming down daily. The rules are changing. I thought the judge laid out a roadmap as to how he was going to get to the end of it. I thought he did a terrific job with that.
High praise from a lawyer for the judge. That's nice to hear. How do our judges see this one?
Well, for two lawyers who believed they had a very big case, they didn't do a very good job of helping the judge out. And I'll also comment on selected readings from letters between counsel. And, you know, as a judge, we don't have the letter in front of us, and you start to quip each other with selected quotes. That doesn't help. 3 issues. The first issue was the litigation hold and preservation. And here we had totally opposing views of what had happened 9 months ago. I would have issued an order that day for preservation, confirming it, and if something happened later on, we could address it, but certainly making sure that the clients were aware of possible consequences. The second and third issues were spoliation and restoration, and those could not be handled, as the judge noted, on the day of this conference. Those we'll take care of down the road. But certainly I would have encouraged counsel to begin some discovery, and let's see where it leads us. Let's take this one step at a time. Let's find out what the facts are, and then we can address them later on.
Judge Rothstein?
There was a point at which plaintiff's counsel virtually listed everything she would have included in the preservation order that she never presented or even brought to the court's attention. There was really no excuse for her not having done that, given a $500 million case. But okay, she hadn't done it. Can't go back 9 months. But I would have ordered her to present that order to the court within maybe 5 or 7 days. One thing he did that was very important, I might have emphasized it a little more, was the idea of cost shifting, to put in plaintiff's attorney's mind that if she really wanted this, she and her client may end up paying for it. That usually has a therapeutic effect in exactly what the demand will be.
How helpful is it as a judge to understand a little bit about the technology here?
It's very helpful. And the more you know, the more you can not be hoodwinked by the lawyers. And it's something that if the judge doesn't know, he certainly can have somebody on his staff. And if you are aware this is going to be a topic of conversation at a conference, you can have that staff member present to assist in those discussions. Or, in a very complicated case, you can even have a third party around to assist. But it's one of those areas where we as judges need to multitask and know a little bit about a lot of things.
And Judge Rothstein, I know you've done some work on this area. What tools are available for a judge to learn about that?
Well, the FJC has already put out a pocket guide on e-discovery, which is being updated, since e-discovery needs to be updated all the time. It's a good place to start. It's not all-inclusive. Even the rules are not all-inclusive because the area is constantly changing, and we're learning more and more about it as it goes along. The costs of e-discovery can be prohibitive. The notions that the Sedona Conference has come up with about proportionality, about cost shifting, all judges need to be familiar with it, because this is a perfect case for seeing the attorneys are not necessarily going to educate you. They're too busy fighting amongst themselves and trying to outguess each other, and judges have to know. That doesn't mean you have to become the world's leading expert on e-discovery, but you've got to know enough of the basics to know who's leading you down path.
There's one other thing that the judge can do. There are some Form Rule 26F orders that require people to meet and confers where there's going to be significant electronic discovery to go through a list of items, so at least those will have been discussed. And they often require not only meet and confer, that you have also somebody competent to be present at the meet and confer, and that could be useful also to the judge.
This certainly is an issue that you want to address early on in a case. In our standard order for these conferences, it's a separate discussion point with a notation that if we don't address these issues now, we don't expect you to raise them later on and delay the progress of the case.
Very good. Well, let's turn to another scenario.
Good morning, everyone. We're on the record here today with Mr. Green acting as court reporter. Counselors, the purpose of this conference this morning is to resolve the issues raised by your proposed competing discovery orders so we can get an order into place.
Thanks, Judge. The first issue is Mr. Dorian wants to rewrite the rules of civil procedure. Instead of the 10 depositions I'm presumptively entitled to, he wants to limit me to 2. The fact is I probably need more than 10, but 2's outrageous.
Your Honor, this is a very simple case. Plaintiff Pringle contends that she was not promoted because of her gender, and her superior, who made that decision, denies that that is the case. And if I take her deposition and Mr. Peel takes Ross's deposition, the case will be ready for trial.
Your Honor, Ms. Pringle's boss didn't act as a free agent here. .go has a corporate culture of promoting men over women, and we can prove that if we just get the discovery we need. .go's board of directors has 11 men and 1 token female. The CEO, the COO, and every other CO of this company is a man. I want to depose every one of those board members and every corporate officer and the company's HR person, who, by the way, also happens to be a man.
Well, Mr. Peel, I have the duty to keep this proportional. And that means allowing only the discovery that's apt to this particular case. Whatever the merits of your case, the amount in controversy doesn't justify unlimited depositions. Mr. Ross and 1 corporate representative should be able to give you much, if not all, of what you truly need. But what I think we need to do here is hit the pause button. Let's start with 3 depositions. Then if you can demonstrate the need for more, I'll give you more, but we'll take it in stages.
Okay, Judge, I can live with that. The next issue is the form in which .go proposes to produce documents. They want us to go back to the Stone Age, review these documents in a windowless, unheated cave of a warehouse, pick the documents, and then they're going to charge us per page to make hard copy photocopies.
Well, Your Honor, I hadn't thought about the idea of an unheated, windowless venue, but it sounds to me as if I'm being accused of complying with the federal rules.
Judge, we know from other cases that .co routinely scans their documents into searchable text files. It's way more convenient, and the documents can be copied virtually cost-free.
Well, with all due respect, Your Honor, I think we cannot be compelled to convert hard copies into an electronic form. Rule 34 requires only that we produce the documents in the format in which they're normally kept, and that's what we propose to do.
Well, that may be, but are you planning to scan them for your own purposes?
Well, we haven't made a decision on that yet, Your Honor, but even if we were to do that, that would be work product, be just like a lawyer organizing documents for use in the case.
I don't buy that having the documents in searchable form rises to work product. Scanning is just a 21st century way of getting documents ready to look at so that the real work product can commence.
But, Your Honor, the point is that under Rule 34, we cannot be compelled to produce the document in a form other than that in which they're kept. The documents are not in that format at this point. We propose to produce them in the form in which they have been kept, and that's full compliance with the rules.
I'm not sure that I can't make you produce the documents in reasonable form, such as scanning, but I don't need to go there. Here's what I'm going to order. If you want to produce documents in hard copy form, fine. But if you ever decide for any reason to convert those documents into electronic form, then you will provide a copy to Ms. Pringle.
But not at our cost, Your Honor. The plaintiff ought to bear at least half the cost of that.
No, the decision to bear the cost in the first place will be yours. You can charge them your incremental cost of making a copy, but I expect that will be de minimis.
Well, let me use a tout sheet, Your Honor, that was prepared for purposes of this conference by one of my technical colleagues to give the court some idea of the cost of what we're talking about. First of all, the plaintiff had demanded emails that are kept on backup tapes. Given the number of custodians and the time frame that we're talking about, we estimate that we're talking about 100 tapes at $1,000 a tape. So right there, we're talking about $100,000. That restored data will take up 2 to 3 terabytes, which will impact our active servers. The costs of running the search are another $25,000, and that's before you get to the attorney time to review them. And so if we are to go down this road, we would respectfully suggest that the cost of this should be shifted to the plaintiff.
Well, Judge, let's take this cost of attorney review time off the table right up front. If they want to review the documents before they produce them, that's their decision. But we shouldn't ever have to pay for that. That's what Judge Shinlin held in the Zubalake 3 decision. As for the rest of the cost shifting, Your Honor has to apply, as you know, the Zubalake factors, such as the extent to which, when Judge Shinlin applied those factors in the actual case, she ordered Ms. Zubalake to pay 25% of the cost of the restoration. But remember, Zubalake was suing for $20 million in damages. As a result of the promotion that Ms. Pringle was denied, she's got to try to support herself and her 3 children on $125,000 a year. Based on that factor alone, Your Honor should dismiss any notion of cost shifting here.
Clearly, I don't know enough yet about this case to determine whether those backup tapes should be restored in the first place, and if so, who should bear the cost. We're going to have to take this in steps. I want the parties to devise a sample restoration and search so we can see how promising it would be to restore the entire group. If it appears that it is desirable, I'll want the parties to give me their input on the factors they think I should consider from Zubalake and elsewhere, and I'll consider.
Well, another discovery case with multiple issues. Who'd like to take the first crack at this?
John, I'll take a quick crack at it. I have an observation to make, and I got a comment I'd like to make. The observation relates to the e-discovery part of this vignette and to the last vignette. Inherent in every rule that I've seen, discussion that I've heard about e-discovery, is the absolute requirement that the lawyers cooperate and collaborate on coming up with a workable mechanism to get this done. You can't just drop this in the judge's lap. You cannot do it. The rules are changing too fast. There's too much move in the e-discovery. And I have not seen in these vignettes that level or degree of cooperation and collaboration between the lawyers to help the judges. That's my observation. My comment on this particular vignette, I thought the judge was fine, except I think she missed the point on Rule 34. I believe what the defense lawyer was saying was I may scan those documents I want scanned in the form I want them scanned and in the order that I want them scanned. That, by most tests, is work product. Rule 26B talks about work product. It's fairly precise in what it says, what work product must be turned over. I thought the judge brushed over that in coming to the conclusion, look, it doesn't cost much to scan. If you're going to scan once, you can scan twice. So if you scan, give it to them. That makes sense generally, but I think in this vignette, she missed a discussion that she probably could have had about the work product issue.
Who'd like to?
I'll follow up. The comment Mike made about cooperation certainly applies in this area, as it does most areas of discovery, and that's why it's also part of the American College Code. And I have had occasion to make that speech with lawyers, with their clients present, reminding them that it was in everyone's interest to get along on some of these points and save the battles for the real battles. I noted 3 issues. First, this is a discrimination case, and the first issue was how many depositions and how quickly are we going to jump into the water. And I fully agree with the staged or proportionate discovery process that she announced. I would have had a little discussion perhaps about just who is being deposed, what's their position, what's their role in this, and get them more focused on the issue of what really needs to take place first before we go on. Then hit the pause button, then decide, do you want to have settlement talks or do you want to keep taking more discovery? In other words, the next time we talk, you'll know more about the case and you'll share that with me and you'll know better how to proceed next. Next was the issue of scanning or putting your opposing counsel in a cavern where there was no heat or water. Certainly the spirit of Rule 34 would say, let's share the scanned documents. If you're going to do that, let's do that. Mike's right, there wasn't any discussion about that. I'm unsure of the nature of the privilege that was being claimed, but I certainly would have gone a step further than the judge in this case and said, I want you to make that decision sooner, not later. How many days or weeks will you have that decision made by? So we can know how you're going to produce it, and then we can tackle the issues from there. And finally, the backup takes and the restoration. I follow the old adage, if you don't have to make a decision, you don't do it, and they certainly didn't put the judge in a position to make a decision on that at this conference.
Other comments?
Sure, I just repeat and emphasize this notion of cooperation. Adversarial approach may have made sense, though there's some question about it in the old-fashioned discovery, but where e-discovery is concerned, the stakes are just too large. And if the attorneys don't cooperate, they are going to cost their clients untold amounts of money and delay cases needlessly. I didn't believe for 1 minute, not 1 minute, that they were going to work with paper copies in this case. I think it was a deliberate stalling tactic. I think it was a red herring, and I think it was needlessly obstructionistic. She questioned whether she had the judge did, rather, questioned sort of tentatively whether she had the right to compel. Of course she had the right to compel. I think she could have put on the record that she didn't believe for a minute that they were going to proceed this way, and she could have entered an order that if they were going to scan documents for their own discovery, that they would make them available to the other side, and in that way get discovery started right away. I mean, the idea that they were going to charge 8 cents a page in this day and age, it wasn't going to happen. And again, I think what it emphasizes is the need for the judges to know the basics about e-discovery.
Great.
I'd just conclude the discussion by saying that, again, if you're not focused on these things advertently as a judge, you're inadvertently then deciding who wins. In this case, the plaintiff won because the defendant now is going to have to scan everything because he's not going to be able to scan only those things that he wants to the extent he wanted to do that before. Therefore, everything will be scanned. The presumption is going to be that he's going to bear that cost, and the marginal cost is going to be minor.
This discussion we just had reminds me of comments that I'll make at conferences. We don't know from this scenario, unlike the earlier one, what's at stake here. How much money is at stake? It appears we have a single person discrimination case. It may be worth a lot, it may be worth not so much. But we've all talked about the expense that discovery is going to take on in this case, and that's a topic that had a place for conversation at this conference.
All right, well, let's move on to our next scenario.
Good afternoon, gentlemen.
Good afternoon.
Good afternoon.
Mr. Perrette, I understand you're here representing the plaintiff, is that correct?
That is correct, Your Honor.
And Mr. Dunner, you represent the defendant.
I do.
I think both of you had earlier, before we began the conference, an opportunity to meet our court reporter, Mr. Coons, who's going to be taking down our proceedings today.
We did, Your
All right. Now, we've got a lot of paper here. As you both know, you're both experienced in my court. You know that my usual practice is to resolve discovery disputes by telephone conference. But both of you represented to the court that court intervention was necessary in this particular discovery dispute, and so I set it down for this afternoon. Now, Mr. Perrette, as I understand the foundation for the requests, you have a problem with the defendant's expert witness list, is that right?
We do, Your Honor. May I explain?
If you would.
Your Honor, the defendant has provided us with this list of expert witnesses, which supposedly satisfies their obligations under Rule 26A2. It does not contain the opinions of any of the experts. It doesn't contain the basis for the opinions. It doesn't contain the facts or data that are relied upon by the experts. This does not satisfy their obligation under the rule. And, Your Honor, it's as if that weren't enough, there are 30, that's 30 names on this list.
That's correct, Your Honor.
Your Honor, there's no way that we can depose 30 expert witnesses.
Mr. Dunner, let's just cut to the chase here. You've got 5 experts to talk about the ability of chemicals to pass through the outer walls of the structures. You've got 4 more to talk about absorption of chemicals through the foundation of the structures, 5 to talk about contamination of the water supply for the structures. Excuse me, Mr. Donner, I don't wish for us to talk over one another. But you've got all of these, and quite frankly, I have to say this is a first for me. I don't believe I've ever seen a list of 30 expert witnesses, even in an antitrust case.
Your Honor, each of these witnesses has special expertise to respond to a different part of the plaintiff's claim here. There are 5 chemical issues and there's 6 structural issues. They're in 30 witnesses. We think the jury needs to hear all 30 as they would explain why this building is clean and not toxic.
Well, then why not 1 expert per part? You get 1 for the foundation, 1 for the outer walls, 1 for the water contamination. I can tell you this with confidence. The jury that we select in this case is not going to sit still to hear the same thing 5 different times. They're just not going to do it.
Your Honor, if I may interject, the plaintiff proposes to call 3 expert witnesses to cover the same areas as the defendant's 30 experts.
Mr. Donner?
Your Honor, I believe the plaintiff is doing that for financial reasons. Their case would be much better presented with more experts.
Your Honor, forgive me, but I have the same obligation that Mr. Donner has to present my client's case. I believe I can do so adequately with 3 experts, and I believe he can do so adequately with far fewer than 30.
But just tell me again, why do you need 6 experts to talk about the outer walls?
Well, Your Honor, the plaintiffs here have filed very general allegations with 5 chemicals in 6 different structural parts, all interfacing. And each ingredient in this toxic soup that they've described needs to be identified and dealt with by an expert as to that ingredient. That's why we need all of these experts.
You would agree with me, would you not, Mr. Donner, that these experts all appear to have advanced degrees in chemistry?
That's true.
And there's not one guy on here who majored in hydrochlorides. There's not another guy on the list who majored in xylene. These are advanced chemists. And I still am unpersuaded that we understand why you need 30 advanced chemists to make out your defenses in the case.
Your Honor, here the plaintiff can put on 1 witness to say that chemicals come through brick walls, through concrete foundations, through metal plumbing, and that can capture the jury's imagination. But showing that that couldn't have happened is more complex.
Mr. Perrett, you have a response to what Mr. Donner just represented?
I certainly do, Your Honor. Your Honor, with respect, this is a ploy by the defendant. They know that we can't depose all of these 30 experts. I don't think they ever had any intention of calling 30 experts. What they want to do is make us pick and choose among the 30 as to which ones we'll depose. And then the ones they will put on the stand will be experts we have not deposed.
That's not true, Your
Honor. Well, true or not, I don't even need to decide sitting here. Mr. Donner, you're going to be limited to 6 witnesses to address the effects of these chemicals. That is, you get 6 if you can show justification for the 6. If, as discovery proceeds, we determine that there is duplication even among the 6, I'm perfectly happy to cut the list even further. As I said, the jury, and for that matter, the court, don't need to sit through the same story being told multiple times. Now, I believe the second item on our agenda this afternoon is Mr. Perrett, I noticed that the plaintiff has objected to just about every one of the defendant's exhibits on grounds of authenticity of all things. What's the basis for your assertion that the exhibits aren't authentic? Is this really a serious objection?
The plaintiff here is seeking punitive damages and has alleged, it's a serious allegation, that the defendant engaged in a plot to cover up the leaking of these toxic chemicals into the structure. We believe that they have falsified reports, that they've altered soil and air test data, and that they have created some documents out of whole cloth. Now, it may be that some of these documents are genuine, but it's also the case that many of them are not. And it's the defendant's fault, not ours, that we can't determine which are genuine and which aren't. And that's why we objected to the authenticity of all.
I don't favor blanket objections in the first instance, Mr. Perret. I think more significantly here, I think we probably are just going to have to part ways on our respective opinions about the meaning of authenticity. I think I have a far different definition than perhaps you do in that regard.
Well, Your Honor, I should add that we do have a doubt about the genuineness of the signature in some of these documents.
Once again, Mr. Perret, I don't think doubts standing alone are going to do it. You're going to have to bring the court some relevant facts that would establish a reasonable doubt as to the authenticity of these documents. Otherwise, we're pre-marking and pre-admitting documents, and your authenticity objections will be denied.
Well, we have a long expert list, and we have a question of the authenticity of some documents here, to a combination of issues that maybe don't arise too frequently. Let's talk to our judges first. How did this judge deal with this, and how might you have done differently?
Well, the first item that comes to my mind is the two topics that were generally discussed, expert depositions and marking of exhibits, I'm not sure would arise in the same conference. So let me take the latter one first. That's probably a conversation that takes place closer to trial. And the practice of pre-marking and admitting exhibits, I believe, is a good one. It's somewhat the way I work as well, especially in our electronic courtrooms where we're showing exhibits to the witness and to the jury at the same time. I agree with the judge that the blanket argument made here was not very persuasive. If the lawyer had some specific objections to signatures or specific emails that were not authentic, he ought to be prepared to present that to the judge either at this conference or at another point in time so that she could rule appropriately on that. Now, with respect to the experts, a discussion that I'm assuming will take place much earlier than on the eve of trial. Now, in this case, we have someone who's advocating, I would argue not very well or effectively, that he needed 30 experts for trial and that all needed to be shown and displayed to the jury. The judge was perfectly appropriate in trying to balance the needs of trial counsel to sufficiently present their case with the judge's obligation to make sure the trial proceeds efficiently and economically. And I will tell you that probably one of the major complaints I hear from jurors over and over again is, why do the lawyers keep repeating themselves? I got it the first time or the second time. By the fifth time, I didn't need to hear it again. Certainly her picking a number of 6, why not? Sounds better than 30.
Judge?
Well, I agree. I agree entirely. I like the way she stepped in on the expert witnesses. That's what these conferences are all about, and that's what judges are supposed to do. She is protecting the jury. She's also protecting herself from hearing 30 different witnesses say the same thing. It's uncalled for that trials should go on that long. The truth of the matter is, and she commented, or the other side commented, he's not going to call 30 witnesses. He's just messing with the other side, trying to get them to spend their time and their money in taking all those depositions. And it's the court's place to make sure that that doesn't happen. As far as the authenticity argument is concerned, again, I agree they would have come in 2 different hearings. I think pre-marking and pre-admitting exhibits is the right way to go, and I would think it's in any case, a small case, large case. I think the old days, and I know in trial practice we still teach attorneys, show it to the other side, offer it, that whole procedure. Very few judges follow that anymore. There's almost no case where we don't pre-admit exhibits so that they just come in very, very smoothly.
Let me ask Mike and Greg, had you been confronted with an opponent wanting to bring 30 experts in, how would you have dealt with that, and how did you think this judge dealt with it?
Not very well. There's not even an entitlement to a deposition until you've got reports, and there have been no reports, so you're not even in a position to decide whether you need to take any depositions. But there is a larger problem which this raises, which is one that's good to keep in mind, and that is it's not infrequent that you may get under Rule 26A1 disclosure a list of hundreds of people that the other party may call in order to prove its case. And you may not have deposed all the right people because there's no way you'd know that. And some courts permit you, if a witness appears on the final trial list that has not been deposed, to take that deposition. And some judges have rules that contemplate that, and that I would urge is a really good idea. And I agree on the authenticity issue. Unless there's a genuine issue as to authenticity, there's no reason to be wasting time. That's a state court litigation issue.
Mike, what are your thoughts?
Well, first on the 30 experts, John, the four of us flipped coins to see who could jump that first. And we all feel about it the same way. And I agree with Judge Rothstein that this is clearly a war of attrition, that this defense is playing with the plaintiff right now, trying to make them buckle and quit under the cost. Because you take depositions, unless the judge does something about it, normally you've got to, the attorney's got to go in and pay for the court reporter and pay that expert for the time. And 30 depositions is ridiculous. On the authenticity, I don't want to be hyper-technical about this, but I think the language that the judge used confuses procedure with substance. And in this regard, I disagree a little bit with my friend Greg Joseph, I think. I think there are some rules in the federal court about authenticity. I think they are very clear. They're set out in Rule 901 of the Federal Rules of Evidence. What our judges generally do on authenticity to move things along is approve the witness list, as Judge Rothstein said, is a good practice, so people know what's coming. But that's subject to the person putting the evidence in, or attempting to, complying with Rule 901 of the Federal Rules of Evidence, which talks precisely about authenticity and how you get it in. The way this judge left it, it was almost as though she had shifted the burden to the plaintiff's lawyer to disprove the authenticity at trial. In other words, she overruled the objection and she mocked them admitted. I would suggest that she might consider overruling the blanket objection, letting the exhibits go forward, but subject to the lawyer who introduces the evidence making the showing required in substance by Rule 901 of Federal Rules of Evidence, the authenticity rule.
And I'd like to address something that Greg brought up, which is that ploys like this don't just happen with expert witnesses. They happen with that witness list he's talking about where you get 100 witnesses listed. Usually they would come in and alongside of it would be the subject matter of that witness's testimony. And a judge very quickly looking down could see, you know, my God, we've got 10 witnesses testifying to this, 20 witnesses testifying to that. And it puts the judge in a position, I'd worry about leaving it to the last minute before trial to sort of figure out who's really going to be called and who isn't, and asking counsel on the eve of trial to start taking depositions. Most trial attorneys would really get very, very nervous about that situation. I think it behooves the court early on to pin trial counsel down and say, look, you got 100 witnesses here. There's no way you're going to call 10 witnesses to testify to the same thing. You're going to have to pick, well, 2. The other reason for that is judges need to know how long a case is going to be. They've got a calendar to set. They have other cases waiting. You need some way of estimating, is this a 5-day case? Is it a 15-day case? Do I have to bump all those cases in between?
You're right, Barbara. It comes up in the context of the judge saying, okay, folks, how long is this trial really going to take? How many witnesses do you really plan to present? And that's where that discussion will kick off, and you'll be able to narrow it down. And I will tell you, quite frankly, a number of our colleagues are putting time limits at trial because lawyers, at least judges feel, are not doing a good enough job of preparing their case for trial and deciding what they need to present and what perhaps they don't need to present. And that's certainly a tool that a judge can use when having that conversation with the lawyers. One other point about exhibits. You know, we now have electronic exhibits going to the jury, and they're viewing a paperless trial in the jury room when they're having their discussions about what has happened. And so these issues of exhibits, we're going to find, I think, more and more, a lot of these issues are going to be addressed before trial or certainly outside the presence of the jury to allow for a smoother presentation, all of which comes back to judges are also considering the jurors' time.
Well, we're going to move now to our criminal scenarios, and with that I want to thank Mike Smith and Greg Joseph, who've been part of our discussion of civil cases, and we'll look at the first criminal scenario next.
Good morning, Ms. Lloyd, Mr. Bright.
Good morning, Your Honor.
Good morning, Your Honor. Mr. Bright, I note you have yet to file your appearance, and contrary to what you told my deputy clerk, you've also not moved pro hoc vice for admission.
Judge, I don't remember saying that to her, but I'll take care of that next week if you want me to.
Any reason you can't do that today?
Well, Judge, I don't return to my office in Hollywood until next Monday, but if you direct me, I'll take care of it today.
I'd appreciate that. What motions do you all anticipate filing in this case? I'd really like to set up a schedule and pick a trial date if possible.
Well, Judge, I have lots of motions in mind, but let me make clear that my client has directed me to insist upon a very, very prompt trial. I've been directed to press that very hard. As to motions, we intend to file the usual Jenks and Brady motions, probably the usual boilerplate motions, and I'd like to, frankly, have all the discovery I could get as soon as possible. In fact, I'd like to have had it yesterday.
Your Honor, I don't see what it serves defense counsel to file a boilerplate Brady motion. He's entitled under the law to Brady if it's material to the defense, and the government will meet its Brady obligations in this matter. In addition, Your Honor, with regard to Jenks Act, he's not entitled to any witness statements until the close of the direct testimony of each witness. However, I don't want to delay trial, and I will be consistent with my office's standard policy, which is I will provide all Jenks Act material 3 days before trial starts.
The court is acquainted with your office's practice on Jenks, Ms. Lloyd, but on the other hand, this is a 120-count indictment. You all have alleged $100 million in losses. How many witnesses do you anticipate calling? Do you have any sense of how long it's going to take you to put on your case in chief?
No, I don't know at this time, Your Honor.
And see, that puts the court in a real bind. Is this a one-week trial? Is this a one-month trial? I know it's early, but what I'd ask each of you to do is to take a look at your evidence. Ms. Lloyd, take a look, get back with the court in, say, a week or so with your best estimate for how long it's going to take for your case in chief. Mr. Bright, I understand that at this point you're working with theories of defense for perhaps, but maybe you could get back with the court in 2 weeks with your best estimate for your defense, if any.
I'll do my best, Your Honor.
Judge, I don't know if I can do that. I don't have a single piece of discovery in this case.
All right, here's what I'm going to do. Ms. Lloyd, I'd like for you to provide Jenks earlier. Let's do a week instead of the customary 3 days. We don't have witness safety issues here, do we?
Not that I'm aware of, Your Honor, but I was just assigned this matter.
Let's assume for these purposes that there are no witness safety issues. I am going to ask that you provide Jenks a week early instead of the customary 3 days. You know, as to motions, Mr. Bright, you mentioned boilerplate. That doesn't seem to me to make a whole lot of sense. Your client's interests are going to be better served if you make specific requests to Ms. Lloyd. The more she knows from you, the more she can provide in discovery.
Your Honor, it would be very, very helpful to me, and I can better produce Brady material to the defense if counsel will advise me as to what his defenses will be.
Just a minute, Ms. Lloyd. I don't have to disclose my defense. I don't even know what my defense is. And before we decide what the defense is going to be, I'm entitled to the discovery that every agency might possess, whether it's state, federal, or local. For example, the SEC participated in this investigation, and I'm entitled to everything that the SEC possesses. Similarly, the Senate Judiciary Committee conducted an investigation. We even understand that various attorneys general have investigated this matter. And until and unless I get discovery material from all of those agencies, I cannot and will not disclose my defense.
Mr. Bright, I understand your position, and so why don't you just file your request with Ms. Lloyd as you see fit? Give her an opportunity to respond, but I do want you to file your other motions not later than 14 days from today. What other motions do you anticipate? And I hope that you can avoid the wasteful boilerplate motions.
Well, let's see. I intend to file a motion to dismiss for violation of the Speedy Trial Act. We contend that the statute of limitations has run and that merits a motion. We also think a change of venue motion is appropriate here. Ms. Lloyd has been working the press hard, portraying my client as the demon king of Ponzi schemers. We don't think we can get a fair trial in this district or any other district in the country.
Well, in all honesty, I haven't seen much media coverage on this case, and so I don't want you to waste your time on a venue motion. I mean, you've got to do your job as you see fit, but I just don't want to raise your expectations on venue.
Well, Judge, I take my job very seriously here, and I will develop and submit specific discovery requests. But the government's obligation then is to examine those discovery requests and examine the files and to respond appropriately with what is discoverable. There's a lot of stuff out there, and unless Ms. Lloyd looks at it, she won't know what's there. Judge, she won't even return my phone calls and emails, so I'm just not confident she's going to do that.
That's not true, Your Honor. Your Honor, I'm going to be seeking reciprocal discovery in this case. It is a two-way street. And this is the way it's done in this district, and I think it's good for defense counsel to learn that.
Well, what about that, Mr. Bright? You do acknowledge an obligation for reciprocal discovery?
Judge, I understand my obligations under the rules of criminal procedure, and I'll comply.
What I'd ask you to do is do your best to identify your theory of defense. Confer with Ms. Lloyd. I know it's early, but she's not someone you want to cross, and you certainly don't want to burn any bridges at this juncture.
Understood, Your Honor.
All right. When was your client's initial appearance?
On the 1st of this month, his initial appearance and his arraignment took place on the same day.
Okay. Then under the Speedy Trial Act, of course, the timing is told while I hear and rule on your various motions. You know, you say you want an early trial date, but it's going to take some time to rule on those motions, and that's going to cause some significant delay.
Well, on second thought, we'll rethink those motions, Your Honor. But I do want to insist on a speedy trial. We're prepared to rely upon the government's commitment to comply with the Department of Justice guidelines on discovery. But my client insists on a trial date on the first business day of next month, 31 days after initial appearance.
Your Honor, that is not fair to the government. This defendant was a fugitive for 5 years. There are dozens and dozens of witnesses in this case. They need to be located. They need to be interviewed. They need to be prepared for trial. And Your Honor, the original prosecutor in the case who investigated and indicted this case, she is long gone from the office. The original case agent retired. He is long gone. It has just been assigned to me. Your Honor, to have a trial in 31 days is not fair. It's just not fair to me.
Your point is well taken, and I don't want you to take this personally, Ms. Lloyd, but as you know, the defendant enjoys various constitutional protections, one of which is his right to a speedy trial. Now, he, of course, could waive that so that you could confer with Ms. Lloyd, Mr. Bright, in hopes of arriving at a plea agreement. The government's case looks pretty strong to me.
Is the court suggesting that perhaps things would go better if my client pled guilty? I have to tell the court, jail is not an option for this client. He has supported his wife and children. He is very active in supporting various charities and raising money for various politicians across the state.
Your Honor, Your Honor, the defendant making charitable contributions and contributions to politicians, that was all part of his Ponzi scheme. That is what gave him credentials in the community and allowed him to rip off these dozens and dozens of victims. And with regard to family, Your Honor, he hasn't seen them in 5 years since he ran off with his mistress. But, Your Honor, let us discuss the possibility of a plea agreement. Let us handle these negotiations. If something can be worked out, I will immediately contact your deputy and ask for a change of plea hearing to be scheduled.
That sounds perfectly fine. And please don't misunderstand me. I do not mean to inject myself into your plea negotiations. The rules simply don't allow that, as you know. I do want the matter to move forward.
Well, there was a lot going on in that scenario and a lot of back and forth between the two lawyers, so let's talk to our lawyers first. What did you see there? What could the judge have done differently?
Well, I think the most obvious thing was a violation of Rule 11. He was obviously trying to force a guilty plea. He was using the Speedy Trial Act as a hammer on the Assistant U.S. Attorney to make an offer. And then he made a statement to the defense lawyer about the case appears strong, so he was trying to force the plea in a case he didn't know anything about, basically. I mean, even the Assistant U.S. Attorney didn't know anything about the case. And, you know, he basically told the defense lawyer, if you don't play nice with the federal prosecutor, get on the wrong side, I'm going to punish you. If you file motions I don't approve of in advance, I'm going to punish you. And if you don't plead guilty, I'm going to punish you. And so I thought it was just inappropriate the way he interjected himself into the plea negotiations.
What about that? I concur that there were at least two moments where the judge did not acquit himself as well as he could have. The first is the one that Tom just mentioned. I think there are, apart from whether he was trying to coerce a plea, just the fact that he would raise the question of a plea on the record in a public setting like that is disturbing for a defense lawyer. The other area where I thought the judge did not have his finest hours was when talking about the venue motion, because even there the judge's reaction was, hey, you may say that there's been a lot of publicity, but I haven't seen much, so you don't have much of a shot. As far as I'm concerned, so don't get your hopes up. I thought that that was an inappropriate tipping of his inclination at that point. You know, the defense lawyer had created his own problems by saying there's nowhere in the United States of America where he could get a fair trial, but that could be dealt with later. I think this is why I'm a little bit more charitable to the judge, is that he was faced in the beginning with a pretty aggressive defense lawyer who was making it pretty plain that his first priority was his busy practice, where he happened to have a client who happened to be before this court. And the judge needed to get control over the lawyer. And at the same time, he needed to try to create an atmosphere of civility. Some of the techniques he used were good. For example, when the defense lawyer said, when he said to the defense lawyer, you haven't filed your pro hoc vice motion or notice of appearance, even though you promised my deputy that you would, the defense lawyer baited him by saying, I don't remember saying that to your deputy, but in any event, I'll get around to it in a week or so. And unless, of course, you direct me to. And the judge didn't take the bait. Instead of saying, I so direct, the judge said, I appreciate that. So he was very deft in getting control over the defense lawyer, creating an atmosphere of civility. Unfortunately, the lawyers didn't live up to those expectations, which he set.
What do our judges have to say to that?
Well, I'll start with the opening salvo in the scenario and indicate that I would have encouraged defense counsel, who has been described as aggressive. I would also add the labels whiner, demander, and a few other adjectives to try and get him on the right course and talk about civility. I would have encouraged him to learn the culture of the court in this jurisdiction so that he understood it. I had a case recently where from someone, a defense counsel from outside the jurisdiction, who decided that they were going to file boilerplate motions and what were described as usual motions. And I got on the phone early on with everyone and said, let's have a conversation. And things change very quickly. So sometimes the judge needs to get hands-on. That being said, at this stage of this case, as I understand it, I'm not sure I would have gotten into some of the detail, as the lawyers here have indicated. I agree with that. I would have suggested that we set a date for a change of plea, get agreement on that date. That date might also be the date for the filing of motions, and get the case moving and progressing. At this stage, the judge wants to move the case in the right direction. I would also note that the defendant wasn't present in the courtroom. I have found that when the defendant is present, it is a good thing usually. They can see the judge, understand the judge. You as a judge can speak to the lawyers and the defendant, and oftentimes that helps, frankly, the lawyers with their handling of their client.
The judge, I think, did one very deft thing, using your description of it, and that was pointing out to defense attorney that asking for an immediate trial date, I mean a totally unrealistic trial date, and also saying that he was going to file every motion that he could think of, is totally inconsistent, because what he was doing was extending that trial date automatically. I think there is an option here that the judge could have used. It would have occurred to me to use it, and that would be to set a trial date within the 60 days, and you make it clear to the prosecutor that she can bring a motion for an exception to the there are exceptions to the Speedy Trial Act. The fact that this individual has been a fugitive for 5 years, and therefore a lot of the witnesses are gone and all, the judge could then deal with that issue as to whether 60 days would be realistic or whether he would grant an exception in the interest of justice. But I would not have, I think I would not have let them leave without setting a trial date against which they could work. What do you think?
I totally agree with that. I think any of those hearings, you got to set dates, and you got to be, firm in having a date set. I mean, my experience as a federal prosecutor is oftentimes defense lawyers are asked for a speedy trial, and they're the first ones to ask for a continuance once a date's actually set. Of course, in this case, there's an absolute grounds for continuance on behalf of the prosecution. There's that exception about effective preparation, the fact that the guy's been a fugitive and the witnesses don't know where they are. I mean, I can't imagine a judge not granting a continuance in that
but
situation.
don't you agree that setting the date
You gotta set the date.
You set the date, and then
Yes.
the prosecutor files a motion.
And another option is to not set the trial date, but to set the date for the hearing of motions, the filing of motions, or a change of plea, which also becomes another pretrial status, and the waiver of time until that date. Defense counsel would be hard-pressed, given all that he said, and he certainly said everything from A to Z, not to agree to waive time until that date. And then, at the next hearing, when counsel are better familiar with the case, you'll get a more accurate estimate of a firm trial date.
I think actually in criminal cases, some judges do want to set a trial date very quickly, and that becomes the default, and everything else gets judged by that initial date. Here you are dealing with a situation where the prosecutor has said, I don't know how long the trial is going to be, I don't know who my witnesses are or where they are, I know nothing about the case. And here's a defense lawyer who says, I don't yet know my defense. So for the judge to peremptorily set a trial date merely for the purpose of keeping control, I think is artificial. I think done right, you set you have a schedule, and you have a very, maybe 1 week or 10 days or 2 weeks, you have a new pretrial conference set, by which time certain things must have happened, and you do the doable within that period of time, and if necessary you do that one more time, and then you start setting a trial date. By the way, the defense lawyer actually said something quite interesting which judges don't normally get to see. A defense lawyer saying, I'm not in control of this. My client's in control of this. The defense lawyer said, my client has directed that he be tried promptly. He insists on a speedy trial.
Well, I think the one thing, whether we agree that it should have been a trial date set or a hearing date set, the one criticism we all seem to agree on is that the judge let them leave without any date. And given the contentiousness between the attorneys, I would think that he can anticipate, or should anticipate, they're going to have problems dealing with each other and getting them back in front of him would be a good thing, knowing they have to come back and see the judge and have something accomplished.
Well,
I'm sorry.
we're going to move on.
Okay.
It's a very rich.
Yes, it is.
It's a rich vignette.
I hate to cut it short, but we have one more scenario to go through, and let's do that now.
And I find that the defendant's plea is voluntary, that it did not result from force, threats, or promises, except, of course, that this is pursuant to a plea agreement. Accordingly, I accept your plea of guilty to counts 1 through 12. Sentencing will be held on October 14 at 10 a.m. in this courtroom. I've ordered a pre-sentence report. Mr. Bright, I'd ask that you arrange with the probation department for an initial Form 1 interview. Ms. Lloyd, what's the status of the defendant's release?
The defendant is released on $100,000 bail secured by his personal residence.
And what's your position on continued release?
The government does not oppose that this be continued, Your Honor, except that we do ask for restrictions on his travel, that his travel be restricted to this district.
Mr. Bright?
That's acceptable to the defense, Your Honor.
All right. Mr. Dunn, I'm permitting you to continue on release, but you understand that you are limited to this district.
Yes, Your Honor.
All right. Now, if you violate the terms of your release, this court will revoke your bail. This means you could forfeit your family's home and face additional charges, potentially. Do you understand that?
Yes, Your Honor.
All right.
Your Honor, if I may raise one housekeeping matter.
Yes.
Your Honor is aware the defendant has pled guilty to an extensive Ponzi scheme. In this case, there are about 50 victims, many of whom want to come and testify.
Your Honor, we object to this evidence. It's really not relevant to anything that you're going to decide at sentencing. We know these people suffered losses, but their testimony really doesn't go to calculation of the loss under the sentencing guidelines.
I think I get your point, Mr. Bright, but as you know, there's much more to sentencing than calculation of the amount of restitution and preparation of the guidelines. The court is entitled to consider all manner of lawful evidence, correct?
That's correct, Your Honor.
Your Honor, the victims have very important statutory rights here. I want to bring to the court's attention some of the victims are present in court today.
See, good morning. Come forward, ma'am, to the podium. Identify yourself for the record, please.
Yes, good morning, Your Honor. May it please the court, my name is Joan Vance, and I represent Mr. Adam Fisher and 4 other members of the Fisher family who were investors with Mr. Dunn's company and lost a substantial amount of money.
Good morning, Ms. Vance.
Your Honor, my clients would like to address the court at sentencing and make sure that their rights to restitution are honored.
I understand. Are there other victims present this morning? Come on up, sir, please.
Your Honor, my name is Woodrow Vernon, and I invested too. I don't have a lawyer, but I want my money back, and I'm afraid I won't get it because he squandered it all living the high life.
Welcome, Mr. Vernon. Thank you for being here. You may be seated. As a practical matter, I'd like to address all the victims who are present in the courtroom this morning or any who might receive notice of proceedings in the future. The court is concerned with any losses the victims may have suffered, and the court is eager to consider the views of the victims. But I'd prefer you to work through the U.S. Attorney's Office. It has an obligation to keep you informed of proceedings and to advocate for your interests. Mr. Vernon, Ms. Vance, is that acceptable to you to work through the U.S. Attorney's Office, understanding that the court is willing to hear from you directly?
Yes, Your Honor.
Thank you. Now, counsel, is this a mandatory restitution case?
Yes, it is, Your Honor. The defendant has pled guilty to all Title 18 offenses, and so therefore restitution is mandatory.
Then the court cannot consider the defendant's ability to pay in calculating the amount of restitution, correct?
Your Honor, we agree that the court is prohibited from considering his ability to pay in its determination of the amount of restitution. However, under Section 3664, the court is required to consider ability to pay for the purposes of determining the schedule for the repayment of restitution or for the purposes of determining whether or not the court should order liquidation of a particular asset.
Do you agree with that, Ms. Lloyd?
Yes, I do, Your Honor.
I can still foresee some complications. For example, does the court have to identify or calculate a specific amount of restitution for each identified victim in this case?
If I may, Your Honor, the procedures are this. Initially, it is the probation officer that makes these calculations as to what the loss is for each individual victim in this case. He or she then incorporates that into the pre-sentence report. We then either agree or we disagree, and only if we disagree then does the court have to make a decision.
But the court is not necessarily required to order restitution on behalf of each victim in every case. Under Section 3663A, C3, the court has the authority to make a finding that the need for restitution is outweighed by the burden that such a process would place on the sentencing itself.
I agree that the court has the authority to not order restitution for each identified victim, but in a case like this where the funds are easily traceable, I find it hard to imagine that I wouldn't order restitution for each identified victim.
I understand the court's position, and in fact, the defendant has agreed to make restitution in his plea agreement, although we have not agreed to a specific loss amount. The defendant has and will continue to make extraordinary efforts to repay the victims. In fact, the victims include members of his family and his former friends.
This is a complex case, and I think we all understand the various tasks at hand and the factors that the court is required to consider. I will ask the probation department to be particularly diligent in its efforts to identify victims and its calculations of specific amounts of restitution. I'd also ask that you continue to confer to resolve any disagreements on amounts or otherwise. And of course, I'm here should any issues remain.
Your Honor, if I may, I feel that it's important to emphasize, though, under Section 3771, that these victims have the statutory right to be heard.
And I hear you loud and clear, and I understand, Ms. Lloyd. I'm concerned, though, by the number and the sheer volume. The notion of hearing from 50 live witnesses gives the court some concern. I think my understanding of 3771 is that it gives me the authority to fashion a reasonable procedure where the number of victims becomes so large that it's impractical. It does give me that authority, does it not?
It does, Your Honor.
Right, and so I'm going to depend on you all to conduct this in the way that we've conducted similar cases in the past, where there have been large numbers of witnesses. You've submitted letters in advance that allows the court to consider positions in advance of live testimony. You can, of course, continue to confer, and perhaps the two of you can come up with a blended procedure of written submissions and a selection of witnesses for live testimony. And then the same analysis applies to the defense, Mr. Bright. As you put on your case in mitigation, you're going to call character witnesses, witnesses for good acts. I see no reason why you couldn't submit some letters in advance and select a certain number of witnesses to testify live.
Understood, Your Honor.
Understood.
Well, once again, we had a lot of moving parts in that scenario. This time, let's start with our judges and see what they thought about how the judge handled this one.
Well, I'll jump in and just say that the notion of victims' rights is a troubling one in a case of this dimension where you have many, many victims. It's perfectly clear that you can't have 50 people speaking at a sentencing. I mean, sentencing would go on for days, and very few judges are going to allow that scenario to take place. And I think he came up with the solution that most of us do come up with, which is a mix, a hybrid situation where some of the victims present their case by letter, and perhaps the U.S. attorney helps select a few, together with any attorneys for the victims, select a few representative victims who will actually be able to speak at the time of sentencing. Now that usually my experience has been that many of the victims really don't want to speak at the time of sentencing. It's a frightening atmosphere for them and an alien one for most people, so there'll be only a few that really want to speak to the court, and it can be narrowed down to a reasonable number. So I was impressed with the fact that he did that, though there were many other issues to which the lawyers may be a little more sensitive than I am. So.
Do you want to start?
The one issue that I was sensitive to, because this happened to me in real practice, is when the judge says that the U.S. attorney would be the advocate for the victims. That's inaccurate. The U.S. attorney has certain statutory obligations to keep them informed, to provide them information, to tell them what's going on, but they're not really the advocate, because in real life often the interest of the U.S. attorney is divergent from that of the victims.
I hear what you're saying, and almost every case I've heard, there hasn't been that difference between the U.S. attorney and the victims. In the garden variety case, the U.S. attorney is very, very capable of presenting the arguments that the victims would present if they were all allowed to speak. So just narrowing it down to one or two or three.
And I absolutely agree. In your average case, you're absolutely correct. Judge?
Let me talk first about the judge's responsibility here of balancing the rights of the parties and the victims with controlling the courtroom. And in a Ponzi scheme case where you have a number of victims, where there may well be some emotionally charged folks in the courtroom, I think it's important for the judge to try and make sure that he addresses those victims, even if the victims aren't speaking. And in that regard, it's our practice to have letters, written letters from the victims, funneled through probation. It's part of our pre-sentence package. It allows lawyers for both sides to comment. And I make a point of indicating in open court that I've received letters, that I've read letters. Depending upon the volume, I may even recite either generically or by name those from whom I've received those letters, to let them know that I have considered it, I understand their situation, and thank you very much for being here today. In a few cases, we have allowed representatives to speak, those who, as Barbara says, aren't fearful or intimidated by the situation. I make it very clear to those folks in that situation that if we're going to say something, let's make it something that maybe is not before me and is something that might be helpful in the very difficult decision that I have to make.
What I would want a judge to focus on, which has not really been the topic yet of comments, is the effect that a victim impact statement has on a defendant. Yes, a judge has to balance the victim's need to be heard and efficiency, but the introduction of this third party into a binary proceeding is like dynamite. It is an emotional difference to have a witness stand up in court and say, I am the victim and here is the effect that this murder has had on my family, or this fraud has had on my family, and it brings people to tears in a moment. What happens when that occurs? You're dealing with an emotional judge.
I will take exception to the comment that this is something that's improper for the judge at sentencing. I mean, part of our obligation is to consider the victims and the effect and the scope of the crime. The collection of letters in a case like this would be important, and if there was some verbal testimony that was appropriate, I think that is okay too. In many state courts, victims have routine rights to speak at a sentencing, whether it's bringing the courtroom to tears or not. And it's the judge's job, again a difficult job, to take into account all the factors that we're required to in coming up at a just and appropriate sentence that is sufficient but not greater than necessary, and hearing from the victims, whether it's in writing or orally or some combination, is a part of that. And a part of our job is to sift through that. Most of us are very aware, for instance, in a murder, that it's going to have a terrible effect on the family and the people who loved that individual. I have rarely been moved to tears by anything that a victim has said in my courtroom, and I don't think it turns it from a rational sentencing hearing into an emotional one. It may be for the other people in the audience, but judges are really used to this. I mean, we do this all the time.
By the way, I wasn't saying it's improper consideration. I said it, if I did, I misspoke. But what I would argue is that under the guidelines, in fraud, for example, you aggregate the amount of damage done. So if you have 50 victims, each losing $1 million, you have $50 million. In aggregating the amounts to reach this number, the amount in controversy number, you assume, or the sentencing guidelines folks assumed, that that translated to actual hurt to people, that people were seriously affected in their lifestyles. So by then taking an individual who has a particularly compelling story and adding that on top of this guideline range, you are basically adding to the penalty in a double dip.
But you don't add, well, we could, this is more an argument.
That's the risk.
The danger.
That's the risk.
I think that the statute tells us that these people are entitled to be heard. Now, the only difference is some are going to be by letter and some are going to be there. And the one thing we've all left out is giving them time limits, making it very, very clear that if they get up and speak at sentencing, they only have 5 or 10 minutes, because otherwise we would be there all week. I think what we're talking about here now are some very unusual situations. In the garden variety case, the procedures that we have serve us well in honoring the statute, but also giving the defendant the consideration that now we've introduced a third party that he has very little means of responding to.
Once again, the judge must be a juggler.
Well, exactly, and ultimately how to handle scenarios like this one that occur in real-life courtrooms is going to be up to the judges who view these scenarios. Thank you all again for taking part in this program, and we thank the American College of Trial Lawyers for working with us on every step of its development. We'd like to know how useful judges found the program and what, if anything, we could do to make the next one better. If you're watching these scenarios at an in-person training program, please take a few minutes to fill out the evaluation form that's provided to you. If you're watching this program online, please fill out the evaluation form that's on our website and submit it to us. I'm John Cook. Thank you for watching.